Hello and welcome to our webinar today on what are the privacy and employment challenges as we transition to the new normal. Before I hand over to our moderator, David Duke, I just wanted to go over some of the housekeeping rules for you. It's best to access the webinar via Chrome or Firefox. Unfortunately, the webinar does not run as well on Explorer, and you may not be able to access the feature such as chat or questions. During the webinar, please feel free to ask questions either via the chat or the questions tab on the right-hand side. If we happen to run out of time, don't get around to answering your questions, don't worry. Any unanswered questions will be answered post-webinar. After the webinar, the link to the recording plus any questions and answers will be uploaded to our website for you to access. Now, I will hand over to David Duke to introduce the webinar and the speakers.
Thanks, Hannah, and welcome. Good afternoon, everybody. This is number 5 in a series of webinars that GemServe have been doing following the implications of the current new normal situation with regard to the COVID pandemic, looking at considerations around security, continuity, privacy, and as today's subject matter, also employment challenges, as well as health data. We've got 2 real experts joining us to take over from me in a moment, and I'll just introduce those guys. We've got Matthew Huggett, a qualified employment lawyer, fellow of the Chartered Institute of Law and a Chartered Fellow of the CIPD. Matthew provides practical advice on employment law, HR issues, and is committed to guiding companies through difficult situations and decision-making processes. Matthew works for an organisation called Carbon Law Partners, and we're really pleased to have him joining us and bringing his expertise today. We've also got Samuel Plantier from GemServe. Now, Samuel is a principal data protection consultant in the data protection team at GemServe. He's also a PhD in law on the topic of consumer law in the digital economy, quite prescient at the moment, and is a qualified lawyer with years of experience providing legal advice in data protection, information technology, contract drafting. And he now, as a consultant, uses that expertise combined with a deep knowledge of the global digital market, consumer and competition laws and data ethics, as well as blockchain and ad tech, helping organisations implement advice in practical ways. So today we're going to talk about the privacy and employment challenges as we transition to the new normal. And for those of you that have joined our previous webinars, you'll note that our health division have talked about the ebb and flow of the pandemic with regard to the changes from recovery to relief mode and then back into recovery and back into relief. Effectively, this is about the pandemic and the different waves and the way that these will have an impact on organisations as they try to address some of the challenges that our speakers will talk about today. So without further ado, I'll move us forward onto the experts. Just to reiterate before we go into that, as Hannah said, this is for your benefit, so please do ask as many questions as you want. If we can't address them during the webinar, then we'll pick them up and we certainly will address them afterwards. So I've introduced Samuel and Matthew, and if we move on to the next slide, we'll start to look at what we're going to talk about in a bit more detail. So I mentioned that we were going to look at health data, the processing of health data by employers within the new normal, and looking effectively at what you can and can't do in that context. We'll be looking at health checks at the workplace. We'll be looking at processing health data from those health checks. And we'll also be looking at health and safety concerns in terms of going back to the office environment. And there are some interesting challenges and opportunities for organisations out there around this, some that I'm sure you're all dealing with, as are we within GemServe as well. We'll then look at employee monitoring, working from home in the context of remote working, and we'll look at some of the rules around online monitoring and some of the considerations to take into account from an employee rights perspective. And we'll also look at some of the data risks that this new normal form of working introduces. So as I say, without further ado, and to make sure we have plenty of time for your questions and answers, I'll move forward to the next slide and let Samuel continue. Thank you.
Good afternoon, everyone. So next slide, please. Let's discuss processing of health data. So basically, even though you have further rules in an employment context, processing health data is in itself a bit particular under the GDPR, because health data is going to be a special category of data. So it means that it needs particular attention. And if you want, in the context of having your employees coming back to work, if you want to make sure that, for instance, the virus isn't going to be spread, or if you want like we have seen in some instances, if you want to perform temperature checks, or if you are offering your employees medical testing, there are a few principles to consider first, as data protection principles, a few rules to have in mind first. So the first one is that you will need basically two sets of legal bases. The first one, as usual, is going to be your legal basis as under Article 6 of GDPR, which is either complying with your legal obligation. So as an employer in general, it's going to be your health and safety obligation as an employer, or legitimate interest. And interestingly, this point actually depends on the country. So some data protection authorities, like the ICO, consider that legitimate interest would be a more suitable legal basis to perform temperature checks, for instance, because obviously it would be in the legitimate interest of the employer to make sure that the safety of everyone is safeguarded at the workplace. But some other countries, some other data protection authorities, so that's the case in France, for instance, would consider that legal obligation is the legal basis to select, to opt for, because it's stronger, and you are actually complying with the legal obligation of ensuring the health and safety of your workplace. So this is something to check locally first. You also need, because you're going to process a special category of data, health data, you also need a ground to process such data. And for this one, it's a bit more simple. It's going to be given by the employment law. So local employment law will give the employer the possibility to process a special category of data. And another principle that is important is going to be data minimization. Basically, an employer will be only able to collect and process what is necessary and proportionate to make sure that the safety of the workplace is safeguarded. And so that would mean, for instance, in the context of temperature checks, it would mean that you would use devices which do not record information, but just show the temperature on the person that is scanned. And then if it goes over, you send this person back, and you process the data further with your normal HR policies, but you would not record the temperature of your employees. What it means as well is that when you are considering to process health data, in the context of employment, you would need to perform a DPA, a data protection impact assessment. And this is important because in an employment context, actually, you have two criteria that are triggered. The first one is going to be that you're processing a special category of data, health data. And the second one is that you're going to process such data from vulnerable people, which are going to be employees in this case. Vulnerable in the sense that employees don't really have the choice in accepting or declining to get their data processed, because the employer has, in general, what we consider the balance of power is more towards the employer. So in general, when you will have when you will be considering processing such data, you will trigger the requirements to perform a DPA, and of course you will have to update your privacy notice as well, because in general it's going to be a new processing, especially if you're doing temperature checks. It's not something you were doing in the past, so you will need to inform your employees of what you are doing, for which purpose, and for which and what data you collect.
Samuel,
yes.
sorry, I was going to say it's a really interesting point you make there in regard to temperature checks and the legal basis. In your experience, how do you balance the need for that with any concerns from the employees about how the data might be used?
That's a very good question, and we are actually advising a lot of clients at the moment in this area, and the advice we give for temperature checks is aligned with what data protection authorities are saying, that basically you are able to collect such data, but you have to use devices that don't record the data. So it's going to be basically really the contactless temperature check device, which is just going to show the temperature of the person, but is not going to record anything. So that way you make sure that the privacy of your employees is protected. And also, more generally, you have to be transparent as an organization of what you are doing, for what reasons, where the data goes, if you collect anything, but you shouldn't. So you have to inform people that you're actually not collecting anything, you are not recording anything. Transparency is really the key word here, I think.
So it's about assurance, really. I understand that. Matthew, it looks as though you were going to come in there. Did you want to add anything to that?
Well, it's really sort of following on to the next slide, actually, because I'll be talking in a bit more detail about the balance of the need for obviously the completing your legalities in terms of data protection, but also there's the balance of power and having the authority to undertake these checks with the employees in the first instance as well, that you need to achieve.
Next slide, please.
So on that point, I mean, obviously Samuel's been talking about temperature checks, and temperature checks are obviously one of the most common ways that employers are at the moment trying to ensure that they have a safe workplace, because that's one of the keys here, is that employers have got to do is ensuring that they have a safe workplace for their employees and for anyone that might visit the workplace as well. And obviously this is in relation to the announcement and the move by the government in terms of the relaxation of the lockdown, and where people who can't work from home are now being able to return to work. So it's the steps that then employers are now having to take to ensure that those workplaces are safe for those people that are returning. And there are a few key points here. So first of all, we've got the issue of consent, because within an employment relationship, if you are going to be undertaking health checks of employees, whether that be through temperature checks, whether that be through questionnaires, just simply asking people about their recent health, whether they've had any symptoms, collecting information along those lines, is that you've got to make sure that you have their consent to collect that information, and particularly in relation to actually undertaking the checks themselves. So if you don't have the consent, admittedly, a lot of the temperature checks that employers are undertaking are as described by Samuel, where they're particularly non-invasive. You're not having to touch the individual. But if an employer is actually undertaking temperature checks in a slightly different way, so a slightly more invasive technique, then clearly consent is required. And without consent, we are potentially moving into areas of fundamental breaches of contract, fundamental breaches of the employment contract, rendering us into constructive unfair dismissal situations, and also ultimately, albeit it's going to be very unlikely, but ultimately, if you don't have consent, it's a potential criminal assault. And so what we need to do is just understand what consent is required and when we're going to obtain it. Now, I've sort of addressed it on the third point here, in terms of the practicality of this, is that actually what we're finding with a lot of employers that are undertaking these sorts of checks is that employees are very happy with it. because of course what it's doing is it's protecting their well-being. It's about the employer taking steps, taking measures to protect their employees. And so generally speaking, what we're finding is that employees are accepting of such processes, as long as all of the issues that Samuel's just been addressing in his first slide there, where we are ensuring that there's transparency, we are ensuring that there's the privacy notices are updated, we are ensuring that where appropriate policies are updated, we're telling employees what's happening to that data, if in fact it is being retained. So all of that is fundamental to maintaining that employment relationship, fundamental to ensuring that you do get consent. And so that's really the core of this. We've also got, I mean, I put here about occupational health as well, that where such checks are being undertaken and where we have got, because you see the second bullet point under this occupational health provision, is that it's where we are collecting data. So Samuel's obviously talked about using systems where data isn't collected. So it literally shows the information and then it disappears afterwards if it's okay. And if it's not okay, you simply address that situation directly with the employee, but the data isn't collected. But if you are going to be collecting data for whatever reason, then what we need to do is we need to make sure that rather than it simply being another employee of the organization that's collecting this data, that data collection is actually undertaken by occupational health. And the reason for that is that, of course, occupational health are regulated. And so that then provides that greater protection in relation to the use of that information, the collection of that information, the storage of that information, because it's being collected by a regulated professional, i.e. a regulated medical professional. And so that's how these checks are actually happening in practice at the moment. But like I said, the key points from an employment point of view is, once you've obviously addressed the data protection point of view, is to make sure that you're getting consent and you're transparent with how that data is going to be used and collected and who has access to it, all your usual data protection principles. The other thing that we need to be aware of, we need to be mindful of, is potential discrimination issues. So we need to ensure that where we are asking for, whether it be asking for information or simply collecting information, that we're not targeting particular groups of employees that then may give rise to potential arguments of discrimination. That doesn't mean that you have to do it right across the organization. If there is an appropriate reason as to why you are targeting a particular group of employees for undertaking these checks, whether that be, as I said, questionnaires or temperature checks, that you can have a justification for that. So say, for example, if you've got a particular group of employees that have greater contact with the public because of the job that they do, then that would be an absolutely fair and non-discriminatory reason to then be collecting data and undertaking checks in relation to those individuals, those employees, in preference to other employees. But otherwise, your starting point should be simply that everybody is treated the same, whether they be staff or, in fact, visitors as well. Can we have the next slide, please?
So I'm going to talk about another example of health checks at the workplace, and giving the example of France. So I was mentioning earlier that in the UK, the ICA was considering that legitimate interest is the right legal basis if you want to perform temperature checks, for instance. The different in France, I was mentioning the other situation where the CNIL was considering that it was more the employer wouldn't have to demonstrate their legitimate interest, but rather elect to comply with a legal obligation. And a few interesting points are that you need to comply, you need to have legal obligation as a legal basis. You also need to rely on occupational health services. And this is an important point, especially for medical testing. The employer isn't able to carry out that, to perform that themselves. In France, you would have to go for the only occupational health services could carry out such tests. The employee would have to notify their employer if they are exposed, if they've been exposed to the coronavirus, or if they've been in contact with other employees. But they wouldn't have to do that if they are working from home. They would just go through sick leave as usual. And an interesting point is that the identity of affected staff must absolutely remain confidential as well. And this is an important point. You are not able to disclose that. So again, this is a bit different than in the UK, where in the ICO consider that you are able to disclose the identity with the close colleagues of the affected individual, the exposed individual, in order to safeguard their health. In France, you are able to tell employees that they've been exposed to a risk, but you wouldn't be able to share the identity of the person affected. The temperature checks must not be recorded, but this is mostly in line with all data protection authorities in Europe. And another interesting point is that health authorities can actually request data from employers. So even though the identity of staff should remain confidential within the company, health authorities can have this information, can request this information. Next slide, please. And I'm handing over to Matt.
Thanks, Samuel. Yeah, so what we're looking at here is the steps that employers are having to take, and really the context in which employers are having to take care of their employees when they return to work, and the health and safety concerns. Now, of course, what we've got is underpinning all of this is health and safety at work legislation. So within the UK, we've got the Health and Safety at Work Act, which, as you can see there, it sets out the duty on every employer, so far as is reasonably practicable, to ensure the health and safety and welfare of all their employees at work. And there is a complementary piece of legislation that also covers Ireland, the Safety, Health and Welfare at Work Act 2005, setting out broadly the very same principles. Now, in terms of then ensuring, alongside, of course, all of these steps that employers can take in relation to, say, health checks become a complementary part of ensuring that there is a safe return to work for employees. And so, obviously, what we've got since certainly the middle of March, and the UK government published some quite detailed and a number of detailed sector-based guidances about working safely, and these were published in the middle of May by the government, so only approximately 3 weeks ago. So they're very recent pieces of guidance. And essentially what that is saying is that you've got to undertake this COVID-19 risk assessment. So you've got to assess what the risks are. And then you've then got to ensure that you have a safe system of work in place to address those risks. And this is then when we return back to what we've been talking about, which is, to what extent do those health checks actually play a part in providing that safe system of work, and alongside all of the other measures that, of course, we're probably all getting very used to in terms of social distancing within the workplace. And then, of course, the employer has got to implement those changes as well. And so this is really the context within which we're looking at the issue of ensuring people's health and safety, and using this alongside the privacy notices and the other policies and communications that employers are having with employees about safeguarding their health at this time. If I could have the next slide, please.
Matthew, I just had a question around
Yes.
that, and apologies because it goes back to a slide a couple of moments ago, but in the context of the new normal, I had a particularly persistent Amazon delivery ringing the doorbell as you transitioned from one slide to the other.
Okay.
You talked about consent, and I just wondered as to whether there were any exceptions in terms of that consent of the employee. And I suppose that relates to the previous slide a little bit in terms of the protecting of the wider employment environment.
Yes, and this is then when employers perhaps have got some quite difficult decisions to make, because if what does an employer do if they don't obtain consent? Now, first of all, if we were to say go back to the example of temperature checks and the completely non-invasive nature of the temperature checks that Samuel was describing earlier, where you point the device at someone, the data isn't collected, then if you don't get consent for that, then my view is that risk in terms of any potential employment issues arising as a result are going to be incredibly low indeed. Okay, I think that's one of the safest forms of actually checking that. If, though, the checks that you're undertaking are slightly more invasive for whatever reason, simply because you can't get hold of one of these devices, then consent is going to be more appropriate. And in fact, when I say more appropriate, more important and fundamentally important, because you don't want to be crossing the line into potential constructive unfair dismissal situations where you are forcing somebody to undergo effectively a medical examination. Like I said, I think in terms of the non-invasive temperature checks, I really don't see that as an issue, and that's the simplest way of being able to do this. Although, of course, we can then go back to all of the various bits of medical guidance about whether, in fact, the temperature checks are a good indicator or not, and how effective they are. And of course, we've got all the other symptoms. So, are we, as an employer, simply relying on those temperature checks, or are we using other tools as well? So, are we using a questionnaire, for example? Are we asking the question about whether they do have any symptoms, asking them to sign a form to say they don't have any symptoms before they come on site? Doing the same with visitors to confirm that they don't have any symptoms or haven't had any symptoms within the last 14 days. And then, of course, we can then move on from that, which is then, well, are we also going to be asking about locations that they have visited? So then it's a sort of movable feast in a way, in terms of what is the risk to you as an organization? How much information do you believe you need? What is the justification for that? The whole proportionality test in relation to the collection of that information. And then in some instances, depending upon that information, the extent to which it's going to be absolutely essential for you to get to consent. And in other situations where, in fact, consent really isn't required, or perhaps just simply the fact that they're walking past you and they can see that you're taking temperature checks, they're giving consent by the fact that they're just letting you do it.
It's a real fine line, isn't it? And I'm sure there'll be other
Yes.
questions on that,
Yeah.
which I'll come back to. And I would encourage any of the audience members to ask those questions and continue to ask through the course. I'll let you get back onto the current slide, Matthew. But thank you.
So, I mean, that sort of feeds into this slide about what information that we're asking for. So I've talked there in answering David's question about symptoms, about locations that people have visited. We've also, of course, got issues, or perhaps may want to collect data, I should say, about, well, who do they live with? You know, are they living with somebody who perhaps is at greater risk? And when I say at greater risk perhaps because of the exposure that they have got because of the job that they do with the person that they live with. And so we've got all of these risks to manage, and then business decisions to make about what information we are going to collect, and then what steps we need to take to ensure that the data that we're collecting is proportionate and legitimate to do so. So meeting all of the rules in relation to data protection, of course, that we can justify it. Undertake our impact assessments to make sure that actually we've done the balance of risk in terms of why we need that information. Because what we've got to do is we've got to ensure that our policies are going to reflect this, to make sure that employees know why the data is being collected. Because if we tell employees what data we're collecting, how we are using it, who's going to get to see it, how long it's going to be kept for, then if we are doing all of that and it is reasonable to do so, then the chance of an employment issue, so say for example someone saying that that is completely unreasonable, you shouldn't be doing with that with my data, that's a fundamental breach of my privacy and or my employment contract, and so therefore I'm resigning, which is the ultimate step that an employee could take in those situations. Albeit they could also put a complaint into the ICO, I appreciate that. But if from an employment context, the ultimate step that they can take is to resign and bring a claim of constructive unfair dismissal. But in order to show that, they've got to show that there's been a fundamental breach by the employer. And so if you're taking all of these steps that we're talking about, then the chance of that happening is greatly reduced. And particularly if you are in an environment as an employer where you have employee representatives in some way, shape or form, whether that be a staff council, whether that be a trade union. And if you talk to them and get their agreement to the steps that you're taking to implement the collection of this data, to ensure the safety, obviously to ensure the safety of the employees at work, then from an employment perspective, you're going to be covering the bases that you need to in order to make sure that there is little risk of any consequence of that. Okay.
Matthew, we've got a question from one of our audience. They ask, and I think both yourself and Samuel will have a view on this, that if they provide employees with an antibody testing kit so they can test themselves at home and they receive results directly from the lab, are you able to ask what the result was?
Yes, you can ask, but of course, again, we've got to go back to the justification, because that goes back to the example that I was giving earlier about perhaps, if you can't undertake temperature checks, then one of the things that you would be doing is perhaps you would be saying, right, do you have any symptoms? Have you had a test recently? Was that test positive? But then the issue for you then is clearly, well, what do you do as a result of being given that information? But even if you ask for that information, of course, to what extent is there obligation on the employee to tell you? If they refuse to do it, because that's the whole issue with the employment situation, is that if you ask for the information and you obtain the information, you treat the information in the appropriate way, then you're going to be meeting all of your obligations. But if you ask for the information and then the employee refuses to give it to you, it's then a question of, well, what steps do you take next in terms of the employment?
And especially in the context of an antibody test, that would be not to check if the employees are currently experiencing symptoms of coronavirus. It's more whether they have had the virus in the past. And I'm not sure why you would have this information. I mean, on a data protection perspective, I would be very careful by asking this information. Again, it would have to come back to the necessity and proportionality. You would need to have a very good justification to ask this information as an employer. So whether it's, for instance, to make sure that people are, the staff that are coming back to work are immune to the virus, whether there is an immunity or not, but then you're going back to matters of employment law and possible discrimination.
Sorry. I was just going to say I misunderstood the question a little bit, because I thought it was just referring to COVID tests rather than the antibody tests.
Yes,
Sorry,
it's antibody testing.
because of course, what purpose does actually having the results of an antibody test for an employer actually provide?
Yeah, I think as an employer, you will need, on the data protection perspective at least, you will need a very good justification as an employer, and I'm not actually sure you can document that. So,
Samuel, on that,
so would be interesting.
sorry, I was going to say on that point, coming back, I guess part of your justification would be formed within the DPIA that you talked about earlier. In light of the waves of the health challenges, i.e., there may well be a second and third wave, and that may well come soon, it may delay. How difficult is it to do a DPIA that provides you that definitive, if you like, in account of the rapidly changing environment?
No, it's a very good question. A DPIA is a living document, so you are able to change, to adapt your risk assessment, your assessment as much as the situation is evolving. So this is already something to know, but I guess in a context as changing as a situation where you can have a second wave, you can't have a definitive assessment from the beginning. You will need to adapt as much as the situation is evolving itself. But the question of antibody is really interesting, because indeed it would help perhaps preventing a second wave, but I'm not even sure that you would have a ground under employment law at the moment to actually decline staff to coming back to the office if they haven't had the virus before. And it's an interesting question. The other point is that normally, if some members of your staff have been sick before, because for this reason, you would already be aware because of the sick leave, for instance. So you would have this information to some extent as an employer. So I'm not sure the antibody testing, as for now, as invasive it would be on the privacy side, is the way forward.
Thanks, Samuel. You talked about coming back to the office and whether you could prevent, and I guess that leads us nicely onto the second half of our conversation topics in terms of employee monitoring. So if we move on to the next slide.
So the employee monitoring is really an interesting topic. So basically, in the context where not only going back to the workplace, but organizations are mostly going, and this is the case at GemServe, mostly going to have a substantial, significant part of the staff still working from home for the foreseeable future. And this raises some challenges. And one of the things as an employer in general is that you want to make sure that your employees are working properly, or that they have all they need, or that they are productive, or that you also, because in general they are going to work on with either their own equipment or with their own internet connection. You also want to make sure that the security, the safety of the information that is transferred between the company, the rest of the staff, and your employee is preserved. So in general, as an organization, you would be interested in monitoring all these sort of things, and the data protection rules around monitoring are actually a bit complex to articulate with employment law. And on the data protection side, the legal framework that would be applicable would be the e-privacy directive on online monitoring. But the rules that are stated in the privacy directive are actually extremely amended in different countries by employment law, and that would actually depend a lot on different countries' approach to employment law, because employee monitoring is one of the area that is still very different, and with very different approaches depending on member states and between the UK, France, and Ireland, for instance. And So what are we talking about? Monitoring may involve, for instance, monitoring the email content, the internet traffic, the use of the telephone, or sometimes location. For instance, if you have vehicles, although it would be a bit less applicable in here. And interestingly, for this kind of monitoring, on the data protection perspective, legitimate interest would be the most suitable legal basis to use. So your legitimate interest as an employer would be to ensure that your employees use devices provided to them for work purposes and in a secure manner. And consent is actually very unlikely to be suitable in this kind of context, in an employment context, because what would you do if your employee say no? Well, if, for instance, you are monitoring your internet traffic for security purposes to make sure that your networks are safe, you wouldn't rely on consent because you don't want your employees to be able to say no to that. You want to actually be able to do it. So consent isn't the way forward. And your legitimate interest as an organization may involve, for instance, the training of employees. So that would be when you listen to phone conversations for training purposes, for training on your staff, improving the quality of service. On customer service lines, you often have this message that the call may be recorded for quality of service. Another example of legitimate interest would be preventing fraud or crime, or detect crime and fraud. For any financial or important assets, or monitor against unauthorized use of your network, for instance. And as usual, we are going back to the data protection principles, which are: the monitoring must be transparent, fair, necessary, and proportionate. Transparent, basically, your staff must be aware that the internet traffic is going to be monitored, for instance, all their phone conversations, all their emails. It must be necessary and proportionate. So, for instance, you would have probably different measures between a bank and between another kind of organization, where the content of emails the employer would not necessarily be entitled to see it. And the last point, the highly invasive techniques are proscribed. So that would, for instance, involve screen recording, involve key logging. I don't know if you've seen that, but in the news, we have actually seen a few news in the US with such policies as always on camera, or managers being able to monitor the screen of their employees at any time. And this is some things that have been happening in the US, and this is very unlikely to be considered as proportionate in the EU on the data protection perspective. But Matt is going to be able to give us a bit more insight on the employment law side of it in the next slide, please.
Thank you. Sorry, I nearly forgot to take myself off mute then. Right, so what we're looking at here is, because often when we talk about monitoring of employees, it's all often considered a bit of a sort of big brother employer keeping an eye on their employees kind of way. And whilst there is, of course, an element of that to ensure that whilst people are working remotely, that they are still working and they're still achieving what they need to achieve, what their objectives are and what the business needs. There are also a number of other aspects to this as well, because there's been an awful lot of talk, of course, about the mental well-being of people whilst they're working from home, and particularly at the moment, and this might be a bit different once we begin to come out of the pandemic and people are working from home in a more normal environment, but we'll get onto that in a little bit. But of course, what we've got unique circumstances where many employees are trying to homeschool their children, but even if they're not homeschooling their children, they have children around, or whether they're caring for other people within their household. So we've got a lot of potential burnout issues and general well-being issues that the employer also it would be appropriate for them to be keeping an eye on in terms of the monitoring that they're undertaking. Employer also wants to ensure that there's appropriate delegation. Now, where a team is working within an office, that's much easier to do. But obviously, when everyone is working remotely, there are new systems, there are new processes that often have to be brought to the fore, which do require an element of monitoring, and particularly then when you move on to such things as quality control and also then harassment. I mean, we're all very familiar with reports of people being harassed online and through social media, but harassment and bullying does occur at work, and often when those issues arise, it's because people say things to one another and things are witnessed. Whereas, of course, in this world of remote working, then obviously that can happen in different formats, and so employers need to be mindful of that as well. And so that then begins to get to the legitimate basis for monitoring that Samuel was talking about just now, in terms of being able to establish, well, why is it that we need to monitor? And if we can establish that legitimate reason for monitoring, then without the consent, because as Samuel said, there's no need for consent in this, it's just establishing what the legitimate reasons for the business to undertake this monitoring are. And then when it does that, it's obviously then got to make sure that it's not too invasive. So we then have a look at the forms of monitoring. Yes, there are the very invasive ways of monitoring that an interesting example that Samuel gave about some situations in America where there's particularly invasive monitoring, but there are other ways of doing it. So there's self-reporting, which isn't the most scientific way of doing it, and perhaps isn't the most appropriate way of doing it, but certainly as a starter for 10 for some businesses, that might be where they want to start. And then it's about moving on to management interaction, making sure managers are doing their jobs, and then moving on in higher volume situations where perhaps the simple process of self-reporting and management interaction that don't work. We then need to have a look at email content, volume, internet usage, telephone use, etc., as we were then looking at, as Samuel was talking about before. But I agree with Samuel that it's simply not going to be legitimate to have the sort of big brother approach that he was talking about there, because there are other ways in which we can do this. So having particular reports on task management and project management that particular employees have got is again another appropriate way of being able to collect information about the productivity of employees. There's many ways that it can be done in a non-invasive way, or at least to be able to do it in a way that data is summarized rather than actually impinging potentially on the private life of the individual as well. If we could move on to the next slide, please.
I think you're going to talk about key legislation as well, guys. Just a reminder, we're into the sort of 10 almost, and I know that people will be interested to understand something about requests to work from home. Be a key thing as we start to come out of lockdown.
Yes, don't worry, I wasn't going to go through each of those pieces of legislation and give a detailed analysis of each of them. So I just wanted to give everyone the heads up of the legislation that covers this particular area. And as I just indicated in my last comment, there's the right to privacy. And we've always got to, when we're undertaking monitoring within the workplace, balance the right of privacy with that as well. And then when we get into the legal issues, the employment issues, I should say, in the employment environment, we're going back to what we were talking about before. So the fundamental basis of all of this monitoring, whether it be health checks or whether it be monitoring whilst people are at home and working from home, it's all about the trust and confidence within the relationships, not fundamentally breaching the employment contract by monitoring it in a way which is in breach of either of those pieces of legislation or of course the ICO codes of practice. It's about making sure that we have an even-handed approach, so we're not acting in a discriminatory way towards any individual or any groups of individuals. And if we then flag up productivity issues, then we deal with that in the appropriate way in accordance with the ACAS Code of Practice and employment rights legislation is set out there in the Employment Rights Act. Okay, so if we move on to the next slide. Yes, so flexible working. Now, this is something that we expect to see quite a lot of once we begin to get into an environment where people can return to work. Or when I say return to work, I should be more specific. When they can return to the office, or they can return to whatever site that they are normally based from. Because a number of individuals are very likely to then say, well, actually, I'd like to put in a request to work flexibly from home because, hey, I've proven it can work. And this is where many employers in the past perhaps have taken the approach of, no, everyone's got to be based in the office, or everyone has got to be based at particular sites, because it doesn't work if everyone's working from home. Now, of course, we will have had a period of probably around about at least 6 to 9 months, where in fact, whole teams will have been working from home and communicating whilst at home. And so unless an employer can actually show that there has been a detrimental effect on the business because of that, then they may have some difficulty in turning requests down. Now, when I say some difficulty, I don't necessarily mean from a legal point of view, because the legal position in relation to rejecting requests for flexible working are relatively straightforward. And the penalties for coming to a conclusion which the employee doesn't like, that is rejecting the request, are also not particularly significant until you then start to get challenged on a discriminatory basis. And the most common way in relation to flexible working requests is on the basis of indirect sex discrimination, because women are generally less able to comply with either the requirement to work full-time or the requirement to work full-time from an office because of childcare requirements. So that's the main risk when we're looking at flexible working applications. But as you can see there, it's set out on the slide in terms of the process itself. It's a fairly straightforward process that would be followed. The next slide shows the process that would be followed in relation to Ireland, which is, in fact, there is no legislation yet in relation to flexible working. Now, of course, you can then have a theoretical discussion about whether you need to have legislation to have a right to ask something, because surely in the absence of legislation, you can ask anyway. So employees in Ireland can still ask to work flexibly, of course they can, and ask to work from home. And there are still going to be discrimination issues, perhaps, if those requests are rejected, but there isn't an actual formal process which has to be followed in relation to such requests yet. But as you can see, there is a consultation ongoing at the moment. Clearly, the outcome of that consultation is probably delayed somewhat because of what's going on at the moment. Okay, next slide, across to Samuel.
Yes, thank you. So a last point to consider is when you have your staff working from home, as I was mentioning, you also have as an organization some concerns about probably the security of the information, and not only your commercial information, but also personal data if you are a business that does involve the processing of personal data. And so that's interesting because the ICO, but also the CNIL in France, have both issued guidelines for organizations on remote working and security, cybersecurity. And basically, you would need to have a few points to consider when you have your staff working remotely. One thing that is that would be easy to implement, or the solution to go to in general, would be to have a VPN to your servers. So when your employees are logging to your information, they use a tunnel that is encrypted and that is safe from external attacks. But you would have a few points to consider. So, for instance, how do you, if you have paperback information, how do you make sure is it safe safely stored at your employee homes? You also have what would be allowed to be sent by email or not. Would you perhaps use a different solution, a different approach, like a sharing platform, a FTP? Which service of video conferencing are you going to use? So there have been a lot of concerns with Zoom recently, for instance, because the Zoom wasn't really protected from external viewers. If you were a bit skilled in how you with using some flows of the service. So that's also something to consider. How your staff is going to access the file. So I mentioned VPN. You can have also cloud storage systems. Is the home actually secured? So that's going to be the security of the devices used by your staff. Are the laptops going to be encrypted, for instance? The response should be yes. If you are going to if the laptops are going to have commercial or personal data stored on it, that would need to be encrypted as a matter of good practice. And the movements of data from home to office, again, a VPN would probably be the best option. And that would actually trigger some interesting questions around data breaches when you have if you are an organization unfortunate enough to have a data breach. It happens to everyone. What would be the responsibilities of everyone? As an organization, you would need to make sure that all the proper security measures are implemented. So VPN, for instance, encrypting laptops. What about employees? What about a laptop which is not encrypted, has been stolen from home, for instance, from the home of your employee? What would be the responsibility of employees? And this is probably some very interesting questions we're going to see in the near future around these points.
Certainly what employers will want to do or should be doing in relation to this is have clear policies and practices and communicating those through to employees, because obviously where there are then data breaches as a result of failures on the part of the employee, then obviously the employer will need to take appropriate action. But in order to take appropriate action from an employment law perspective, it just needs to have flagged up what the rules were in the first place. So not leaving the employees to guess how they should be treating the data.
And we have in mind the Morrison case law as well,
yes,
which was very into that. The responsibility of Morrison's had been actually held at the end. So I think it was upheld at the end. But Morrison was held responsible for a misbehavior from the employee, which was completely malevolent, but still, because Morrison didn't take the appropriate steps to make sure that the employee didn't have access to some sensitive data during the notice period. The Morrisons was held responsible, even though the breach was the result of an employee fraud, of an employee misbehavior.
Some really interesting points there, guys. I'm sure we could talk about this for much longer.
Probably.
Yeah, thank you for that. And I think particularly interesting around the requests to work from home, leading into some of the considerations around data risks that you mentioned there. We've got a couple of minutes. If there are any questions from the audience, this is your sort of last 2 minutes to do so. I've got a couple of questions that I wanted to ask you guys. And as we move through to the next slide, little bit of wrapping up information as well that I wanted to give for those that have questions or questions that arise later. As we wait for the slide to move through, we talked about DPIAs a number of times, and in the interest of time, I'll go through this quite quickly. But one element solution, if you like, is around addressing and providing that accountability, and probably also empowering internal people of that accountability and that responsibility. So, you know, setting out this 4-step process that we recommend that you can easily work yourselves using ISO guidance is about reviewing and taking approach to first determine whether a DPIA is required, and then looking at communicating when it is required, when it's not required, delivering that DPIA and using it as a way to demonstrate the consideration that you've taken around and then using those steps to embed that by design culture, which will help in terms of addressing a number of the points and Samuel have made. So look, coming up on the screen, quite topical, Matthew and Samuel, but I wanted to ask you in sort of 30 seconds, what's your view on contact tracing app and the rules and norms and the need to get wide enough coverage?
Yeah, that's a very good question, Dave.
It's a difficult one in 30 seconds.
Yeah. Yes, indeed. Yeah. I guess, I mean, you can probably find resources that would discuss this topic in more detail. But my opinion is that if you want it to be efficient, it needs to be built on trust. And you don't have trust from citizens without being transparent and being absolutely clear on what how the data is going to be collected and processed. I'm not sure any of the solution is actually of the solution proposed at the moment is actually matching these requirements. If you want it to work properly, you need to have a very high adoption rate. So you need people to be actually invested in it, to trust the system, and trust is really the key here. Otherwise, only a few people, or very limited people, will install it, and then it would be worthless, I think.
Yeah, I think from my point of view, from an employer's point of view, it's very much driven by what the government recommendations are going to be. I don't think that any employer is in a position at the moment to really go off on a frolic of its own, for want of a better way of putting it, in terms of requiring their employees to have such a test and tracing app.
Matthew, thanks, and thanks for such a concise answer. On the screen at the moment, you'll see some details where you can reach out to either Samuel or Matthew if you've. So please do reach out. As I said, this is the 5th in a series of webinars from GEMS. Web address there, which we'll share with you afterwards. There are and details of ones that are coming up, and we've got some interesting looks on and data protection as well. All that remains, thank you for joining. I hope you found that useful, and we'll hope to see you again at the next webinar. Thank you very much.
Thank you.
Just as closing off the webinar here, thank you everybody for attending, and thank you to our presenters for an informative and interesting webinar. As mentioned by David, link to the recording and any information, useful information, will be posted onto our website for you to access, and please look out for this link. Do also look out for the future webinars. Thank you for joining today, and have a great week, and hope you can join us next time. Bye bye.